Hi there, folks. This is Sam Price on with another episode of Probate Notes. And I think we're going to have a really good episode today because I have on Greg Broege. He's a partner at Ajalat, Polley, Ayoob, Matarese, and Broege. Thank you and welcome to the show, Greg.
Thank you. Happy to be here.
Awesome. We're going to talk today about property taxes, which I think are in everybody's mind being here in California. We have some weird rules, don't we?
Uh, to say it, yes. There's even a case that says that property tax has strange esoteric rules so even the Court of Appeal agrees that we have strange rules.
Agreed. So before we get started, I kind of want to get a little bit to know you a little bit. Can you tell us a bit about your legal background and how you got to where you're at?
Sure. I started at Latham and Watkins, mega firm, doing a lot of M&A, corporate finance type work. I wouldn't say it was my favorite type of work. I come from, on my father's side, a family of lawyers, and they always gave me the advice of specialize, be highly specialized, and the earlier you specialize, the better. So I was kind of looking for places to go while I was at Latham, and then the Great Recession hit, and they basically laid off our whole class, which wasn't the worst thing for me because they gave a good severance, and I was already in the process of moving, so it didn't really affect me that much. I didn't know much about property tax when I joined the firm I'm at now, but I really liked the people who worked there, and it ended up working out great. So, sometimes it's just dumb luck. If I wanted to specialize, they were highly specialized, and I ended up really liking the practice area.
That's perfect. Oh, it sounds like it worked out really well. I want to talk to you about what happens when someone passes away and what happens to the real estate that they own and the property taxes. And so, can we first talk about what happens? Is there some type of a change in ownership when the owner of real estate dies?
Yeah. So just to give a little background on what we're dealing with in California, we have Prop 13. And so, Prop 13 rolled all values back to their March 175 values. Those values were then capped and could only increase if you had a change of ownership or new construction. So a lot of people know if they go out and buy a new house, the house is going to get reassessed, likely, not always, but likely to the purchase price. And they'll pay taxes on that. And that value can only go up by at most 2% a year. The trend factor is 2% or inflation, whichever's less. So that's kind of in their head. If you have someone who owns property and they die, that is also a change of ownership because I don't know if you know this, Sam, but a dead person can't own property.
I've heard.
We don't have zombies yet in California. Maybe we'll get them eventually, but
Mhm.
we don't have them yet. So a dead person can't own property. So that also causes a change of ownership. But unlike when you go out and buy a property where there's a purchase price, there is no purchase price when someone dies. So it's left to the assessor to do their own analysis to come up with they think the fair market value of the property is as of that date, reassess the property as of that date, and that would be the new taxes going forward unless there's some type of exclusion in the past. And what people often don't know is there's requirements. The change of ownership, even if it's owned in a trust, even if the trust is being litigated, no one knows who's going to it, or someone dies intestate and it's going through probate proceedings. The change of ownership date is the date of death, and you have a duty to report that to the assessor's office, that death, within 150 days of the date of death under the Revenue and Taxation Code. So the law changed, a massive change in the law in 2021 to the parent-child exclusion. So if that house or if it's any other property is not the principal residence of the parent, the property is just going to be reassessed to fair market value. So there is no more parent-child exclusion for any property other than a principal residence. So if it's a vacation home, it's a strip mall, it's a little duplex that they rent out, the property is going to be reassessed. Your taxes likely are going to go up significantly. And how significant is basically how long has your parent owned the property? If they just bought it 6 months ago, they won't go up very much. If they bought it, 16 years ago, they'll go up a lot. If it is the principal residence of the parent, Then, again, this was a major change in the law. Now you have to have one of the two kids who are inheriting the house move into the house within 1 year of the parent's date of death. And not only move in and make it their principal residence, they also have to file for the homeowner's exemption within 1 year of the date of death. And so the homeowner's exemption is a pretty simple form. It gives you a $7,000 of value. So roughly 75, 80 bucks of tax savings a year savings, but it alerts the county that that is your principal residence now, the kids, one of them, and they need to get that within a year. If they do not get that within a year, they will get reassessed to fair market value, just as if there was no exclusion available. However, if they file it outside of a year, they can get prospective relief, which means from that tax year forward, so long as they also file for the parent-child claim timely.
So let me be sure I understand. It's mom passes away, whichever child lives in the home has to file this homeowner's exemption. Is that right?
Yes,
And that's a 1 year deadline from the date of death.
correct.
Now, is there's some other type of exemption for disabled veterans? Does that also count as a homeowner's exemption?
Yes, either one works. So if you have disabled veterans or homeowners on it, it'll be fine.
If mom passes away and it goes to son and daughter, if son lives in the house and he files a homeowner's exemption within a year of mom's death, then there will be no reassessment for property tax purposes. And if son later moves out and daughter moves in, daughter would now have to file a homeowner's exemption
Homeowners.
within a year of the son moving out. Is that the rule?
Yes.
Okay.
Yes. And so with the son, in addition to the homeowner's exemption, has to file a parent-child exclusion claim form. That is a different deadline. That is within 3 years of the date of death, or before the property is transferred to a third party, or within 6 months of a notice of reassessment, either a supplemental assessment or escape assessment that reassess the property as of the parent's date of death, whichever is later. So you get the later of those deadlines. In addition to having to file that, you still might get reassessed because under the old parent-child, if you transfer to principal residence, there was never a reassessment to a child. Now there's a comparison of the current base year value to the fair market value. And how the new law works is you take the trended base year value of your parent, the Prop 13 base year value that your parent had. You add $1 million to that that's trended under inflation every few years. So right now it's about $1,050,000 that you add to it. If the fair market value of the property is more than that 1 million plus the trended base year value from your parent, then that difference is added to the parent's base year value. So if you have a property that's appreciated greatly, even though you can fully qualify for the parent-child exclusion, you still may see a reassessment. Now, if your property is worth less than $1 million, you're never going to get reassessed as long as you qualify for everything else, because doesn't matter what the prior trended base year value is, you'll be under the exclusion amount. And so even in certain situations, you can still have an increase in property taxes under the new Prop 13. You can do everything right and still, Prop 19 parent-child. You can do everything right and still get a reassessment.
So it's not that it's not reassessed at all. It's that the first $1 million is not reassessed.
The first $1 million above the trended base year value.
Okay. So if when mom dies, the base year value was 400,000 and the house is worth $1 million. That's a $600,000 difference. And that would not be reassessed.
That would not be reassessed because you take the 4 million, you add the million, that's 1.4, and the $1 million is less than 1.4, so there'd be no reassessment. But if you switch it and say the house is worth 2 million,
okay,
then you do 2 million less 1.4, so that's 600,000 difference. You'd add the 600,000 to the old base year value, which is 400,000, and so the new base year value would be $1 million. So you're better off than having no parent-child, because with no parent-child, you'd be assessed at $2 million and paying taxes at a little over $20,000 a year, you're not as good as the old parent child where you would have kept that $400,000 base year value and you'd be paying taxes a little over $4,000 a year. You're now somewhere in between where now you're paying taxes on $1 million assessed value, which means you're paying taxes at about a little over $10,000 a year. So you're about $10,000 better off than without the parent child, but you're about $6,000 worse off than the old parent child exclusion.